Welcome back to the Talking Hedge. I'm Josh Kincaid, Capital Markets Analyst and host of your Cannabis Business Podcast. Today, we're going to take a look at an article from Ganjapreneur about how the feds are filing a lawsuit over a CBD company's health claims. To help us do that is an attorney and angel investor, Katrina Glogowski. Katrina, thanks for being back on the podcast.
Thanks, Josh.
All right, so just kind of jumping into this article, looking at it, I guess the U.S. Federal Trade Commission in April, they filed a lawsuit against the CBD company Whole Leaf Organics over the company's claim that their products treat cancer and prevent or reduce this pandemic, this crisis. And so the legal action is a departure from previous enforcement methods by the agency and the Food and Drug Administration against companies that make health claims about CBD products. So this is kind of interesting. We've seen a lot of maybe letters, but we haven't actually seen any lawsuits. So what's the difference?
Josh, what we're seeing here is the government's response to fraud, trying to take advantage of people in a very trying and difficult time. And when we have a company touting that their product can assist with difficulties during this difficult time, the government really has no choice. And if you look at parallel claims saying this particular drug, pharmaceutical level drug can assist you during this time, the government has also taken action related to those fraudulent claims or unfounded claims as the case may be. And that's what we're seeing here. Now contrast that with previous enforcement actions where they're like, change your website. This really isn't the way to go. Please, we've seen a lot of please. The FDA, I want to say late December of 2019, issued 15 warning letters to CBD companies for making unfounded claims. And I think the federal government in this action just went ahead and said this went too far by saying that this product can treat current difficulties that people may be facing. And I think the government took the right action here. We say all the time on this podcast, Josh, don't say CBD cures cancer. Just don't do it for a variety of reasons. But this particular company, Whole Leaf Organics, made a mention that their product may be able to assist individuals with cancer treatment and with the current difficulties. And the government said, too far, stop, pull it off the shelf. I have actually read the complaint and the stipulation in this case, and Whole Leaf Organics has already withdrawn such claims and will no longer be making claims related to cancer or the current issues facing the United States in June of 2020 related to their product. So hopefully this won't put the company out of business. They'll straighten up and fly right. But it does certainly outline the danger of making unsubstantiated claims regarding the medicinal and pharmaceutical benefits of CBD, which we talk about all the time. Buy these CBD infused leggings to get rid of cellulite. No, don't do this. So anyway, that's what this is about.
I guess I'm curious ultimately what the difference is between Kyle Turley, who said the same thing. Ultimately, I guess he backed down. Are you able to infer or take a guess as to what the difference is between what he was tweeting about, this, curing this same pandemic issue versus these health claims? Is it because Whole Leaf Organics ended up not pulling that literature or changing it? Did they just ignore it? I mean, what happened?
Josh, I can't say whether or not Whole Leaf Organics received warning letters, whether they refused to abide by warning letters, or whether the federal government just cranked down without any warning letters. But Kevin Turley was making very similar claims, and he's been taken down from most platforms because of it. So I just, if you're a CBD company right now, or a psilocybin company right now, just don't do this. Just do not do this. Do not make claims that your product can cure, diagnose, or treat any illness, because you will run afoul of the federal government.
So, like you mentioned, when enforcing federal marketing rules about the health claims of CBD, federal regulators have typically sent warning letters to companies accusing them of breaking those rules. But I'm assuming that, so with Kyle Turley's example on Twitter, he kind of just backed off. This company must have got a letter, didn't respond in time, and then the lawsuit is the next logical step, I'm assuming.
One would make that assumption given the previous pattern of the federal government, or the federal government's stance has now changed. Look, we issued warning letters en masse in late 2019. That was the warning, and there are no more warnings. So I can't say which way it went, but no company should be making these claims.
Yeah, so they said there's no proof of any product will prevent or treat this pandemic, or that any CBD product will treat cancer. So the administrative case against Whole Leaf is set for January 7th, 2021. So the FTC notes that it's only filing an administrative complaint when it has reason to believe that the named defendants are violating or about to violate the law.
Yeah. I would say that they got tagged maybe a little bit harsher than another company might have been tagged because of their claim related to the current troubles in the United States. It's a hot button issue, and they went too far. That would be my guess.
So this might be a good time to transition into our own example with Kincaid. It's a medicated bandage, and that's problem number one, is you can't really say medicated. So I've taken some notes with a trademark. This client of mine is based in San Diego. It's a military top 10 award winner for reducing pain, reducing healing time, and reducing scarring. Problem is a lot of these government organizations want proof of that. So the first issue is that right of first use. Can you briefly explain that? Because the registration was initially refused because first use was not, it didn't happen before the filing date. That was our first problem. We have to correct that because we had first use before we applied, but they weren't aware of that.
Josh, first use has to do with filing trademarks and showing that your trademark was actually in commercial use prior to you filing the trademark.
Well, very similar to the story that we just covered, we also got a notification from the Federal Food, Drug, and Cosmetic Act that we can't have anything that's medicated. So anything that's intended to use for diagnosis, cure, mitigation of treatment, or prevention of disease, and or intended to affect the structure of any function of the body basically needs approval, right? So would you essentially kind of throw that under the same issue of what we just discussed in the previous article?
Yes and no. Both products, both enforcement actions have to do with the claims of treatment, diagnose, or cure an illness, and that would be independent of CBD. I mean, you could put aloe vera on that bandage and say that it's a medicated bandage, and I think you would run into the same problem. And I would just reword that. That's an easy workaround. And that's just the packaging, not the product itself.
And to clarify, that's actually in the social media. That's on Instagram. So they did their due diligence. They went into social media and they're like, you got to clear that up. And so we're like, yes, whatever.
Oh, absolutely. The FTC's action against Whole Leaf was all about their online presence, social media, their website relating to the claims. And here you see that as well. So you definitely don't want to use the term medicated. You could say treated bandage. You could say enhanced bandage, any other word besides medicated.
There was a California lawyer who said that medicated was a broad enough term. And I'm assuming if you have enough money to fight the case, you could probably make it. But if you don't want to go to court, then just avoid using it.
But I do think that's a totally different issue than having CBD on the bandage. So I think you have three things.
Yeah. So that third point here is interesting because I'm not sure it's timely, right? It's interesting that they're talking about identifying goods featuring cannabidiol to the extent that the applicant's goods are derived solely from the cannabis plants that meet current statutory definition of hemp. Such goods may be lawful. So is it that just we need to let them know that it's hemp derived CBD instead of assuming or presuming that it's cannabis, or, that it has more than 0.3% THC?
I think that's what they're trying to communicate with this information, that it is not clear from your packaging and or the information available on the internet that this is a hemp-derived product as opposed to a cannabis-derived product. And I think that in their own little way, they're trying to help you out here by saying, if this is hemp seed oil on the bandage to enhance the effects of the bandage itself, that might be a workaround.
It seems to be the workaround for Amazon as well. If you say hemp extract or hemp seed oil, you can get into Amazon. If you use CBD at all, you're out. So that's the workaround maybe with e-commerce, but in terms of packaging, I think just putting the quote solely derived from hemp with a delta-9 tetrahydrocannabinol concentration of not more than 0.3% on a dry weight basis is the dead giveaway. They're kind of just giving that to us as putting that verbiage on the package somewhere. And so that'll be some things that we change.
Right. I think this isn't horrible. This wasn't a denial. And you're lucky. It's actually very difficult to get a trademark in this industry for a variety of reasons. Kush. Nobody is ever going to be able to trademark Kush because it's so ubiquitous now. So there's those types of issues. And I want to trademark Blue Dream. Yeah, good luck, because it's just too ubiquitous. So the fact that they're trying to help you, and I view this correspondence as an effort to help, really is a good sign. And none of these are unduly burdensome. Number one, that you didn't have first use. Well, now you have first use. You have a product and it's available. Yay. So number one is resolved. Number two, using the word medicated on the package. That's easy. Just change the packaging. I mean, it's going to be a horrible loss money-wise for the company, but they didn't say no. They just said change it. And then the third and final point related to CBD, cannabis, hemp, they told you, it's in quotes, they told you what to write on the package. So this is all good. Make some amendments, resubmit, and you'll probably get your trademark to Kincaid.
All good pieces of advice. So with that, I think we're going to roll this one up. I want to thank my guest, Katrina Glogowski, angel investor and attorney in Seattle. Thanks for being back on the podcast.
Thanks, Josh, and good luck with your Kincaid.
I'm going to need it. I am Josh Kincaid. This is The Talking Hedge. Don't forget to like, share, and subscribe, or don't, and I'm out. Don't forget to smash that like button on your way out and check out these other videos that we've got.